Good morning and welcome. My thanks to all of you for joining us today on this important session discussing legal and insurance considerations around COVID-19. COVID and its impact on our tourism sector is something none of us could have anticipated, and the reality is that there really are no winners here. I want to stress at the outset that this is important for us to remember because the topics we're talking about today are very sensitive and highly emotive. The issues aren't black and white, so I'll ask you to please be patient with us and engage with us constructively so we can help you steer through these very muddy waters. We know how difficult this has been for everyone, and we understand the frustration and how unfair this whole situation is. So let's focus our energies on what we can control, and let's hope that this session brings you some practical advice and answers on some of the pressing legal and insurance questions that you may have at this time. On that note, we would really love to hear from you, and you can share your questions or your views by clicking on the chat button below and perhaps telling us where you are connecting from today. You'll also be able to ask a question throughout the webinar in the Q&A folder, and we'll endeavor to get through as many of those questions as we can. So the chat folder and the Q&A is how we would love to get feedback from you. We are also recording the session, and we will share it with Tess and the South Africa team. So now I would like to welcome our panelists today. Andre du Toit from SATIB is probably a familiar face. You will have seen on the invitation that Dewald Silea was going to join us today, but you'll be happy to hear that he's actually fighting your fight with Santam today on behalf of SATIB's customers. So he's having a meeting with Santam, and Andre very, very gratefully agreed to fill his shoes. So my thanks to Andre for joining us. We also have Stefan de Beer from Martin & de Beer Inc., who's going to be addressing some of your legal questions today. And of course, you all know Tess Bruce from South Africa. She's also in the room. So on that note, I'd like to hand over to Tess just to give us a brief welcome. Tess, the floor is yours.
Thank you. Lovely to be here. And a huge thank you to both Andre and Stefan for joining us today, sharing their experience and their expertise. And thank you, Natalia. You've been such a good friend to SITE, and it's always good to have you on board. And thank you for doing this for us. For those of you who don't know SITE, SITE stands for the Society of Incentive Travel Excellence, and we are the African chapter. As Natalia said, we're an industry in distress right now, a lot of questions, a lot of prickly pears that we have to deal with. So we do welcome the opportunity to discuss some of these issues with our panel of expertise. And let's not waste any time. I'm going to hand over to Natalia, who's going to run this for us. And over to you guys. Thank you so much.
Thanks, Tess. Love your background. Looking very, very Capetonian. Right, so let's get right into it. And I'm gonna start with the difficult topic first, just off the back of the carte blanche segment that was held on Sunday last week. So let's get right into that, because a lot of the questions that we have received just as an industry, and we've received as part of this webinar, has been around this idea of business interruption insurance and what is viable, what's not viable in terms of claiming. So I'd like Andre just to unpack for us, what is business interruption insurance? What is the difference between standard business interruption insurance and then those COB and CBI extensions where you might potentially have a claim if you have those extensions? Andre, over to you.
Thanks, Natalia, and thanks, Tess, for inviting us to address these, as you say, very, very sensitive issues at this stage. I think the distinction needs to be must be made between business interruption policies and those with, as you say, cancellation of bookings extensions or the contingent business interruption extensions. Standard business interruption cover really requires the existence of physical damage for there to be a claim. In other words, a fire or a flood, and that's just really the basis of business interruption. If your hotel burnt down, if your bed and breakfast burnt down, there would be a period where you build up your establishment again, and that would be your period of interruption, business interruption.
Sorry, Andrew, if I can just interrupt you, your sound has gone a little bit wonky, so I'm struggling to hear you. That's a little.
How's that? Is that
it's a bit
better?
a bit tinny. Not sure what's happening there. Let's give it a go and see how we go.
All right, let's try and see if that works. So standard business interruption was always there to cover material damage. following fire, flood, whatever the case might be. Some of the policies have extensions where no physical damage could result from, beg your pardon. The consensus from insurance is that COVID-19 is not covered because of the material damage component. But there are elements and policies that have got an extensions to infectious disease extension. So policy holders with what we call a cancellation of bookings or a contingent business interruption extension to their business insurance policies should really be speaking to their brokers to ascertain whether they have a potential claim. These extensions are the very reason for the ongoing debate. And the debate is amongst senior counsel in this country. It's not between you and I. Insurers have taken the stance that the disease extension is only applicable where there's a localized case of COVID-19 and that the loss of revenue can be directly attributed to that particular outbreak. And that is what is being challenged. So I don't have any clear answers for you now. All I can say to you is that from our perspective, we've certainly engaged with 2 senior counsels. There are differing opinions, and in the next week or so, those opinions are being addressed with not only insurers, but with the possibility of legal action. So I think ultimately, at the end of the day, that is really going to be determined by the court of law.
Okay, so this will become
so short story is if you've got those extensions, engage with your broker and make sure that you've got a claim registered at least.
Okay, so if you haven't lodged a claim already and you do have those extensions, the first thing you need to do is to go and speak to your broker and ensure that if you're not in it, you can't win it, essentially. So you have to be in it to win it.
Correct.
Okay, got you. So the segment that was held on Carte Blanche on Sunday night addressed the difference between the COB and CBI insurance extensions. And we know that not everyone has those COB and CBI extensions, but not everyone can have those CBI and COB extensions. So there are certain businesses that wouldn't normally go for those extensions. Is that correct, Andre?
Yes, absolutely. It's, again, each business will have its own needs, and those needs, it's up to the insured to make sure they engage with specialist brokers to be able to determine their needs and have those discussions with their insurance brokers so that they can actually advise them on what covers are required and whether those extensions are relevant to their particular businesses. And that would change on an each and every basis.
Sounds still a little bit funny. I am struggling a little bit to hear you. Apologies to the listeners who are on. We're having a little bit of an issue, but what we will do after the fact is just transcribe the session so that you have access to the text version as well, so that it's not just the audio. So my apologies for that. Thank you, Andre. I think I'm going to give you a little bit of a rest and hand over to Stefan. So Stefan, if you would unmute yourself, that would be great. So one of the questions that we had was around liability in a world of COVID. And now we're starting to do our lockdown levels. We're starting to come out of lockdown and we're going to have guests coming on board. If somebody at my property or somebody in my vehicle says that they have contracted COVID-19 while they've been on one of my tours or once they've been at an event that I've hosted, for example, what kind of liability do I have as a product owner or a venue, for example? Is that something you'd be able to respond to?
Yeah, obviously that comes down to the specific set of facts of every matter. There's in our law, unfortunately, no such thing as a one-size-fits-all. Reasonability in any event is paramount. So what courts will do, because obviously whoever the one who alleges must prove. So if you allege that you contracted the virus from a specific venue or from a specific function that you attended, then you must prove that there is a causal connection between your attendance and you contracting the virus. Now that is not, I think in these times, that will not be something that can be easily done, simply because of the incubation period of the virus, firstly. Secondly, simply because the lockdown regulations have now allowed us to move more freely, which will be difficult, will make it difficult to narrow down exactly where you were and where you could have contracted the virus. But yes, if that link can be proven, and at least on a balance of probability be proven sufficiently so that a court is convinced, then you can be held liable. However, the reality of the matter is it is a damages claim. In other words, you must quantify your damages. As I said earlier to Tess, the mere fact that you contracted the virus doesn't in itself mean that there is damage suffered. You have to convince the court that you've suffered certain material damages, whether it be either physical damage or emotional damage, or you had to incur certain medical expenses, etc. But you have to prove those damages in order to have a valid claim. So first you have to prove the cause, and that you have on the merits of the matter that you have got a case and a claim, and then secondly you have to prove that that claim in itself is quantifiable. So it is going to be difficult for anyone, but again, it's difficult to say at this stage specific and particularly how the courts will interpret this, simply because I believe that the floodgates of litigation is only starting to open about now. So since we haven't dealt with a pandemic of this nature, I believe, and I might be wrong, but I believe that the courts may have a little leeway when it comes down to applying the law, and they'll probably do so more in favor of the consumer than they would the business or in our case the owners of properties or events.
So there are, and we saw this on this carte blanche segment as well, about the responsibility of the insured, or the responsibility of the business to prove and to make sure that they're backing up all their claims. And it just seems to be very onerous. And I know people who are on this call at the moment are frustrated, shaking their heads and thinking, how on earth am I going to produce these medical records, for example, that indicate that I've literally had COVID on my property or within a radius of X amount. It's very frustrating when your business is experiencing what it's experienced, to have to then this burden of proof, essentially, that you have to show. And as you say, it is a situation that is so unprecedented. Andre, if I could ask you to step in here, just from an insurance claims perspective, we've had a lot of people saying, well, why should I have to prove all of this? Just unpack the responsibility of the insured as it pertains to this burden of proof, essentially.
Andre, you're on mute.
So, can you hear me clearly now? Am I still sounding tinny?
Very tinny, very tinny.
That's so odd, Natalia.
Natalia also muted.
You might have to unplug your earphones and use your computer mic. I think that might be a little bit better. Sorry, guys.
Okay.
That's better. That's better. To go.
I'm unplugged and ready to go. Okay, so if there's a little bit of background noise every now and again, please forgive me. Obviously, we're all working from a home environment. So just to perhaps recap the question, in terms of what is the responsibility of the insureds in order to, during the claims process as such. So it's, in these circumstances, and it's no different to others, it is the responsibility of the insured to prove their loss. And the situation makes it particularly difficult because when it comes to the infectious disease extension, and I'm going to refer to that because we need to accept that there are no claims at this point certainly are going to be paid out because damages haven't occurred, material damages haven't occurred for the traditional business interruption to be triggered. So when it comes to the infectious diseases extension, you've often got scenarios where you've got a radial limit of 10, 20, 40 kilometers, 50 kilometers in some, where the outbreak needs to happen within that radial limit or at the premises. So insurers are, and arguably, they are providing a very onerous and sometimes what we believe to be pervasive requirements in order to determine the loss. So they're saying that you need to go and find a particular case of outbreak within your radial limit, which is sometimes near impossible. You have to find that particular individual with those medical records and whatnot. We believe that's pervasive, and we are fighting that case. And then you have to prove the direct link between that particular case and the interruption or the loss that you've suffered. Now, that's where we are, and that's why Deerwald is not here today, because that's the exact argument we are having with insurers at this point. However, as onerous as it seems, certainly our recommendations and our claims teams and your brokers should be helping you formulate and gather as much information as you have possible. Get that, frame it, send it in as part of your claims submission, because we do believe that conversation is not over.
Thank you, Andre. This is the time where we are all thinking about our liability. And if we had been able to forecast a pandemic of this nature and its impact on tourism, we might have had other things in place to try and mitigate the risk that we're currently experiencing in our businesses. So we mentioned earlier with Stefan talking about what happens if I have somebody that's on my property who contracts COVID and the liability that's involved. Is there any insurance or any way of covering myself post-pandemic or within pandemic, if you will, to make sure that I'm protected from an insurance perspective if somebody does come to me and say that I'm liable in any way?
For me?
Yes.
Okay.
I'm thankful that one's not for me.
Currently, like Stefan mentioned, to prove liability or your negligence in exposing someone else to COVID is going to be quite tricky. As long as you adhere to the standards that have been set out by government and whatever, then you should be fine. That's if you're lucky enough to have anybody in your place, which is highly unlikely. But obviously there's staff and whatnot that need to be considered. Post-COVID, in fact, from 1st of June, and many insurers have put it in as an exclusion. If you had the cover before, you should be able to claim. But following the exclusions on the removal of clauses, there will be no cover as far as COVID is concerned going forward. And it's not just in South Africa; that's a global result. And that extends beyond liability policies. It's the breadth of liability policies. So if you talk about directors and officers liability, general public liability, all of the insurers are removing COVID from or putting COVID exclusions into their policies going forward. So it's highly unlikely that there will be cover for this or any other pandemic type scenarios going forward. There are releases and there's a bit of news going on about brave groups that are putting together or restructuring types of insurances or funds that may be able to cover catastrophic events like pandemics, but nothing yet in concrete.
Andrea, I found it incredibly useful because I got quite angry when I saw, and I'm just being very honest, as someone who works in tourism, I got very angry when I saw the notification from insurers saying that from the 1st of June, that there wouldn't be any cover. But it was very helpful for me to understand the relationship between the insurer and the reinsurer, and the reason why that stance has been taken. It is cold comfort, but I felt a little bit better understanding that. Do you want to just explain why those insurers have taken that stance and that relationship with the reinsurer?
You're quite right, Natalia. Thanks. So you've got insurers in South Africa are the ones that take your premiums, and then they themselves take out insurance with large global companies we call reinsurers, and that's where the majority of the catastrophic cover sits. And they've essentially have turned around and said, we will not provide you, the local insurers, I won't mention names, but the largest insurers in South Africa have all got reinsurance. So they've been dictated to by the reinsurers, who have then come across and said, you will not, as far as the treaty we have with you is concerned, we are no longer allowing you to provide cover with that is related to COVID or pandemics or whatever the case might be. That's as simple as that.
Okay.
They're not allowing them to.
Yeah, still irritated, but that's
better.
Yeah,
absolutely.
Better that there is a reason why, and they haven't just done it for the fun of it. So sorry, I'm monopolizing the attention here on Andre, but many of the questions that we received are insurance questions. So let's just actually focus on one that we received from Chad, where he said, I'm sure a lot of companies have, or if not, should have reduced their insurance on vehicles. We have reduced 90% of our fleet and reduced our costs down by 25,000 Rand a month. Is there any opportunity to reduce in any other areas, especially for businesses that are not operating, as the risk factor has been reduced? Andre, do you?
Yeah, Chad, brilliant. And I think your broker's done a great job to start by getting your fleet cover reduced. Absolutely. If it's on, sadly, if your fleet's on bricks, your cover is reduced. There are other areas where you can reduce cover too. If your turnover and your bed nights are reduced, for instance, you could have a look at your liability covers, because they are generally rated on the number of bed nights you have and the income that you would receive during the period. And there are a few places. You must engage, don't do what your neighbors do. You must engage with your broker about your specific needs, because you still need motor insurance, for instance. You just won't need expensive cover that takes you onto the road, but you still need fire and theft cover for those vehicles, okay, which will attract a far lesser premium, but it's required nonetheless. For the liability side, you still will have exposure to liability, but it will be reduced, and your premium will be reduced because of the fact that you haven't got that flow of businesses coming in. So yes, there are various ways that your insurer that your broker can help you reduce premiums. But on the flip side, and I hate to say it because we're all trying to save a little bit of money here, but there are also other exposures that you didn't have 3 months ago. We're all working from remote environments now. Cybercrime has escalated exponentially. Directors and officers are exposed because of the decisions they're having to make during the COVID space are fairly onerous. So directors and officers liability cover is something that people need to be considering. So as the environment changes, so does your risk, and those discussions need to be had with your brokers.
Thanks, Andre, for mentioning that cybersecurity aspect. I've hosted 2 webinars around cybersecurity in the last 2 months, and it has been frightening how it has impacted small businesses, never mind, large businesses. You think they'll go after large businesses, but they actually go after every single person. But one of the other questions we received around liability, and I don't actually know if there's any insurance against that, I probably need it, is around POPI and the fact that now you've got to collect all these people's information, these contact details of everybody. To what extent does POPI or GDPR come into play, because now they're sharing this information with you? And I'm going to ask Stefan to actually comment on that, but I will just respond, as a marketer, essentially. I'm pretty sure that the POPI, for example, we know hasn't been enacted yet, but obviously GDPR has. So that would be an element that one would need to consider. But I would assume that legislation in a time of state of disaster might have some kind of impact, for example, on things like POPI. So Stefan, do you have any views on that?
I tend to tell my clients mostly that, listen, we as attorneys probably have one of the easier jobs simply because we specialize in common sense. The reality of the matter is all of us are now on high alert, and the consequences of what's just hit the world and South Africa and the industry specifically will only reveal itself within the coming months. I believe that should you collect information, should you have access to client information, both personal and professional, your liability, should you not protect that information sufficiently, will obviously increase exponentially, as Andre mentioned. The shocking nature of the cyber crimes, and I think that we are being attacked. South Africa as a country is being attacked about 47 times per minute or per second or something, simply because cyber criminals love South Africa. I think it's the second or third highest rate of cyber crimes is in South Africa. Cyber criminals love our jurisdiction. So you as a business who has got access to information from clients and tourists and travelers, you have a massive responsibility to ensure that information stays safe, because as Andre mentioned, the risk side is shifting. You can't just simply believe that because my business is now ground to a halt that my risks have gone with it. No. The reality of the matter is your risks only changed, and your responsibilities increased on a different side of the business, one that you probably didn't even consider prior to this pandemic.
Yeah.
Would you like to weigh in there, Andre?
No, not at all. I agree absolutely. I think he's summed it up nicely.
Okay, great. A lot of questions around, and I know the pain that has been mentioned over the last 2 months around the fact that I, either as an intermediary in South Africa, DMC, or the end property, for example, or the end venue, has clients overseas, and the jurisdiction overseas requires 100% refunding. So a lot of the questions that we have received over the last couple of months, and particularly around this webinar, Stefan, I'm going to hand over to you, is around, you know, the fact that we now have to refund all these deposits, that there's a knock-on effect. The customers are insisting 100% refunds in spite of contracts that are in place. How do I know, or at least what recourse do I have? Do I have to pay everything back? You know, if there's a contract in place, do I have to pay the money back, even though the legislation in the United Kingdom or Europe says something different? I mean, what recourse do we have in South Africa? What contract law takes precedence, essentially?
Okay, that depends again on the circumstances of each event and of each matter. The reality is, if you are a local operator or local owner of properties or intermediary, you are bound by our laws. And at this stage, the major issue that we foresee, obviously a double-edged sword, is the Consumer Protection Act, simply because it applies to anyone who does business in South Africa. So even if you have international travelers who now demand refunds, they are entitled to make use of the Consumer Protection Act as basis for their claims. You as a operator or as an owner is unfortunately not entitled to keep all funds paid to you. You are allowed to ask a reasonable or charge a reasonable cancellation fee. So even if you do have an agreement in place that dictates that you are entitled to keep all the money, that is unfortunately not enforceable in as far as the Consumer Protection Act is concerned. You may charge a reasonable cancellation fee. That comes down to the circumstances of every matter. Certain establishments will incur a massive amount of costs weeks before the parties arrive or the traveler arrives. Others won't incur any costs until they arrive. So that comes down to the specific set of facts of every instance. I won't be too bothered by what international law dictates or what other jurisdictions at this stage dictate, simply because if you have, let's say you are a travel agent on this side, or you're an operator on this side, or in South Africa, and you have an agreement in place with an international travel agency situated in Europe, for example, who are bound by the European travel holiday package travel directive, they are entitled, they are supposed to make refunds. They are liable for 100% refunds, the agency on that side or the agents on that side. If you don't have an agreement with them in place that dictates or specifies that you are liable for same refunds simply because they are, then you aren't obliged to make full refunds. You can still charge your cancellation fee, your reasonable cancellation fee, and then refund the remainder. However, what we have seen over the course of the past few months is the existing agreements between international travel agencies and operators with local operators and establishments is shockingly one-sided. Andre and I have had discussions and debates on the reality of the matter is that most insurers won't even cover you for those type of knocks because the agreements in itself dictate that you indemnify the international agents. You as local establishment or operator indemnify the international agents. So they simply can proceed to settle whatever they have to settle, fork out refunds left and right, and then just come back and claim the said refund from you. And your insurer won't be able to cover that because it's no longer a case of negligence. It's no longer a matter that can be covered by insurance. So we must really take care when it comes to signing any form of agreement, especially with international agents. Although the laws differ on their side, the law of contract in South Africa is clear. Our courts will interpret the contract as far as possible, as strictly as possible. So the terms of the agreement will dictate how we go about things, as long as it's not, it doesn't contradict, in this instance, for example, the Consumer Protection Act. But yeah, in short, if you don't have an agreement with an international establishment, apart from business relationships and PR issues that you may have, if you refuse refunds, there won't be specific liability on your side to fork out a full refund unless they demand one, and unless they can prove that you haven't incurred any form of costs. If you have entered into an agreement with them, just take care. You might be in for a tough time.
Yeah, so what I'm hearing from you is that many of our local guys might have signed an agreement that was given to them by the international customer, for example, and perhaps not understood or not aligned it with what their rights are in South Africa, and then also from an insurance perspective. How do we create that alignment? I know we're now looking at it, hindsight is 2020, and we're looking at it probably too late, but this is not going to come to an end anytime in the near future, and we can expect things like this to happen in future. So if you were going to give me advice as a business owner, how do I make sure that I am aligning my T's and C's, for example, in a way that is South African friendly and also insurance friendly? What could I do?
I think before I give this one to Andre, I think from a legal perspective and from the experience that we've gotten is have your terms and conditions drafted either by an attorney, or send your current terms and conditions, send it through to your broker, who can then forward it to the insurer to have the insurer decide whether or not they will cover it. But don't only send your terms and conditions. Make sure that the terms of the agreements that you have entered into with international agents or operators or establishments, let the terms of those agreements also be sent to your insurer or your attorney or your broker, to ensure that the cover that you've got in place will in fact respond if you continue to do business on the way that you have done thus far, or if something happens in terms of those specific agreements. I believe ultimately it's an insurer's interest as well to see exactly the basis on which our clients conduct their business. So it'll help them to mitigate their own risks. It'll help them get a clearer picture of exactly what it is you do. And you'll be enabled to at least then know, if something happens, this is exactly what I can expect from my insurer to respond to, and this is my risks should I fail to for example take care in drafting the contracts or signing agreements that are favorable to a South African perspective.
Andre, from a brokerage perspective, is that a responsibility that you guys would have, trying to help customers align their T's and C's and their contracts from an insurance perspective?
Yes and no. It's certainly within our interest. So we would encourage clients to bring those agreements across our desks. But at the end of the day, we're insurance advisors and not legal or contract advisors. So we would always, we're very familiar with the 2 or 3 clauses that that will often sort of, what's the word I'm looking for, would fall foul of the insurance covers that they have in place. So we would always recommend those through to a legal team, often through to Stefan and his chaps, or others that we have, but because it's a legal issue at the end of the day. But certainly, and as Stefan states, the insurers will often be prejudiced by the contracts the existing contracts that a lot of the larger UK agents specifically are asking our clients to sign. So don't just sign them blindly. Rather, for peace of mind, send them through to your broker or your legal person, preferably both, to make sure that your contracts are deliverable and they don't prejudice insurers at the end of the day.
Okay. Stefan, a lot of questions around, and I've had them the last 2 months, around force majeure. Just unpack that force majeure for me, because I've had people say, well, government invokes force majeure. Then I've had people say, no, it's actually the supplier that invokes force majeure. What is it? Why is it important in a contract? What should we be looking for when we see it in a contract?
Okay, I've also obviously had quite a substantial number of questions with regards to force majeure over the course of the past few weeks and months. The reality of the matter is similar to what we've stated thus far. The law is also, well, almost always only consists of a specific sets of facts of specific matters. Even in force majeure, there's no one size fits all. There are certain aspects that one must look at. Firstly is if you've got an agreement in place, if there's a contract that's got a force majeure clause, the clause will dictate exactly what happens. Again, that also is subject to, for example, the Consumer Protection Act, simply because force majeure is a common law principle, and if that contradicts what our legislation dictates, then legislation will take precedence. So it's not necessarily sufficient to state, but yeah, I've got a force majeure clause that says in the event of an act of God or any other event that will effectively make performance by either one of us a matter of impossibility, then both of us will be released from our responsibilities. For example, I am a traveler myself. I paid a deposit to a certain establishment. Now I can't travel. Now, neither does the establishment. Now I have to deliver on the 2 beds or the 1 bed for how many nights. But I'm not necessarily liable to make payment in any event because I can't use the service. It's not my fault. It's not the establishment's fault. However, the establishment can't simply say, because of force majeure, I don't have to perform. You don't have to perform, but neither do I. So I am effectively entitled, as far as I'm concerned, I am entitled to receive my deposit back, less whatever reasonable cancellation fee you may then charge. So there's a contractual aspect, and then there's a common law aspect, and we must also look at what the legislation states. Remember, something like the Consumer Protection Act isn't always applicable in any event, simply because it comes down to if a juristic person is the consumer in this instance. If the juristic person has a turnover of more than 2 million rand per year, then the Consumer Protection Act largely won't apply. But then again, you as an establishment run the risk of them proceeding with a claim for unjustified enrichment, because there was no basis in law for me to make any form of payment and for you to render any form of service. So that's the one side of things. Force majeure is a flippin' interesting concept, but there are three sides of it. So if firstly, it can either make performance objectively impossible forever, so performance will not at all be possible at all. Then there's a possibility that performance of certain aspects of the contract may still be able, or that you may still perform certain of your responsibilities in terms of the agreement, which would entitle you to certain rights, whether it be payment or to deliver certain services. Thirdly, impossibility only for a specific period of time. That comes down to various sets of facts, as already mentioned. We believe it's possible to argue that most of the cases that we'll be dealing with from a tourism industry perspective could come down to, okay, but it's only been, the force majeure can only be claimed for a certain period. So we can at least negotiate with our clients or with our travelers to, let's rather postpone your trip than to cancel it. However, again, it comes down to, is the Consumer Protection Act applicable? And as a consumer, as a party to any form of agreement, you are entitled to cancel. It just comes down to what the consequences of that cancellation would be. And unfortunately, CPA doesn't specifically state pandemics. It merely refers to hospitalization and death. But I believe that the courts will interpret, in all likelihood, that things like pandemics will fall within the ambit of what will require you as an industry, when it comes to refunds, not to penalize someone for cancellation as a result of force majeure. But again, that's not something that has been vented in our courts yet.
I feel a little bit like a guinea pig in the tourism industry. Like, we're going to have all these legal cases that are going to go to court, and precedent is going to be decided based on all the lessons that we as a tourism industry are having to learn at the moment. It's a bit of an
unfortunately, yeah.
It's the truth.
Yeah, Chad has actually just posted in the chat, would you clarify what happens if no force majeure clause is in your contract? What people do not understand is it does not automatically come into play, but would need to be in a contract between two parties, correct? So if there is no such clause, then one would revert to common law. I do not believe there is any provision in South African common law for force majeure currently, if I am correct.
Okay, but remember, our common law is mostly interpreted by the courts, and the courts have set down clear requirements and ground rules for force majeure. So there are certain requirements for whoever decides to invoke force majeure. So force majeure is a general concept and a general term, an implied term of any and all agreements, whether it be verbal or written agreements. If performance is impossible, and objectively so, then you can invoke it. Either you as a supplier or you as a customer can invoke force majeure. You must, however, just convince a court based on the set out and standard principles that has been in our law for many decades and set down by the SCA on a number of occasions. You have to prove objectively that you could not perform. And that is something that is difficult to do in certain instances. However, simply because it's not, simply because you can't perform is not necessarily grounds for you to proceed with a claim of force majeure. I see here you said, would we not refer to supervening impossibility of performance? Remember, it comes, you'll see we use force majeure simply as a binding term, as most oaks also refer to as vis major. There's a number of terms that we colloquially only refer to as, in this instance, as force majeure, because most of us have heard that term recently. I mean, there are other terms, including supervening impossibility of performance. However, the courts and most commentators have already said there's no really any material need for us to draw distinction between the concepts. We all understand what it comes down to.
Stefan, don't mute yourself just yet, because I have another question. I know you'll be able to answer it.
Sure.
And I'm connecting two questions, because Sarita has come through, and we've had a question previously around this the supply chain, this channel, and how we make sure that we protect the integrity of this supply chain. And from Sarita's perspective, she's saying, how do we support hoteliers, accommodation providers, as ultimately the financial buck stops with them in terms of absorbing the entire loss? DMCs cannot or won't absorb the risk and will simply put a stop sell on a supplier if they charge any penalties. On the other side of the coin, we'll have the DMC or the customer or the tour operator overseas saying, what happens if I now pay the accommodation establishment, the venue, etc., and some of those go bust due to the lockdown and travel bans? So both questions are looking at different parts of the supply chain and just protecting the integrity. What can be done to protect that integrity? How do we ensure that it's fair and that accommodation establishments can rely on their DMCs, tour operators, and customers to support them? And on the other side, what recourse do I have if I'm a tour operator or a customer and I've paid a deposit and that establishment then goes bust as a result of lockdown? How do we protect that channel? Do you have a view on that?
Yeah, well, we've had a discussion, or a few discussions actually over the course of the past few weeks on escrow, which is something that we've considered to bring to the industry to assist them. It won't assist with short-term cash flow. However, it will protect the integrity of the value chain to the extent that everyone knows, listen, money has been deposited, here's a receipt, the money is being managed in terms of an agreement that has been set up and is controlled by objective third parties or law firms, as we've set out to establish, and that will at least give everyone some form of peace of mind. That's on the one side, to ensure that the funds already spent or the funds already paid, that they are protected against whatever happens from there on. The second part of the question, however, if you paid a deposit and whoever goes bust, the operator or the establishment goes bust, unfortunately, in these times, again, if utilized in terms of the escrow agreement will provide that those funds are returned to whoever made the deposit. If no escrow is utilized, then normal laws of insolvency will apply. So you will then fall, unfortunately, and in all likelihood, at the back of the line as a creditor. So you'll have to prove your claim with either the liquidator or the trustee, and they will then determine whatever portion of your funds you can get back. In the Free State High Court, we've got standard practice of anything between 10 and 20 cents in the rand will have to be proven in case of liquidation. So you can be lucky as a customer, should anyone go bust where you paid a deposit, to receive anything close to 10 or 20 cents in the rand.
Great, thanks. Okay, so I'm going to go back to insurance now, Andre. So I hope you are unmuted and I hope your sound is happening. And that is around passenger liability. So please would you check with our panelists on the status of passenger liability. Is this still necessary, as based on my experience, this is covered by the Road Accident Fund, yet many companies, especially in tourism, may still be paying this. Any views on that, Andre?
Yes, absolutely. It's not new. So it's a bit conflicting, because tour operators are legally expected to carry passenger liability. That's a legal requirement. On the other side, you've got the Road Accident Fund, which states that you can't sue the wrongdoer. So therein lies the conflict. However, from the outset, we did seek legal opinion, and it's certainly, we haven't had any case being tested at this point. So really, the advice is, at this stage, it's not an expensive insurance, is to stick with the law. have passenger liability in place for fare-paying passengers, and keep that at sort of minimum levels, to be sure that you can at least have some defence costs covered in the event that it goes to court, which it is likely to. But that process can be long and drawn out, and your clients are, if you do have an injured client in a vehicle accident, the outcome is going to be long. It's going to be drawn out, and if the road accident fund has anything to do with it, probably not going to be very well compensated. So as a group, we've also introduced a cover. It's a personal accident cover called PACSure, which pays out in vehicle accidents on a no-fault basis. So from our perspective, and it's specific to the tourism industry, so from our perspective, we believe that you should have a little bit of a combination of both, depending on your circumstances, but I certainly wouldn't rely on the road accident fund to look after losses as a result of vehicle accidents. During these times in COVID, obviously you're not transporting clients around, so you wouldn't need passenger liability as far as fare-paying passengers are concerned. But obviously as soon as you pick up operations again, that's a requirement that you would need to get going again.
Sorry, did you say road accident fund and rely in the same sentence? Because I don't know.
No. No, definitely not. And that's the reason why we need to have all of these other things in place, because I just don't think we can.
Okay, gotcha. Right. So the last thing I want to address is staff. We talk a lot about the safety of guests. We talk a lot about ensuring that our guests are safe and having insurance in place to make sure that we're protected if something happens with our guests, but we don't always talk about staff. And, you know, I think about it from a business travel perspective, where you might, for example, have a staff member that has to travel for business, and possibly very reluctantly traveling for business at this stage. What are your thoughts around the liability that employers have when it comes to kind of forcing their staff, I guess, if that's even possible, to travel? Is that something that one can do? Or if you have any liability yourself as an employer, if that employee gets sick. So first of all, Stefan, can an employer force somebody to travel for business at this time? Do I have any liability if an employee gets COVID on my premises or as a result of their work? And then, Andre, from an insurance perspective, how can I indemnify myself from employee claims?
Okay, from again, question in our law is it reasonable? Is what you've requested from your employee, is it reasonable? Would it be possible to achieve the same objective without having your employee travel? If yes, then you as an employer, unfortunately, has the onerous responsibility to ensure that whatever other avenues and options are available to you as a business is then taken up rather than traveling, for example. That will also apply to social distancing. It will apply to working from home. It will effectively apply to everything in every part of your business. So if it's absolutely necessary for us, for example, us as a firm, we've got a few matters outside of Bloem. We have to travel to other provinces and other jurisdictions to tend to matters. However, what we have done is, because most matters don't really proceed to trial if they haven't been set down for trial at this stage, we simply ask a correspondent in whatever jurisdiction to tend to the matters, to have the matter postponed, so that neither us or our either advocates or candidate attorneys are exposed any more than they reasonably should, and that would be regarded as doing something reasonable. If, however, the matter is set down for trial and I'm the one who prepared for the trial, then I would unfortunately not be able to simply send someone else to attempt to postpone the matter, because the matter has been set down and I'm the one who will have to tend to it. So it comes down to again, what is reasonable under the circumstances. Can you force an employee to travel? Yes, but only if it's reasonable and if there aren't any other reasonable alternatives. So, and I think from the liability aspect that Andre will address now, again, you've also got the issue of vicarious liability. So you must also be concerned not only with your employees coming after you from a liability perspective, because they contracted COVID at the workplace. You must also be careful that your employees don't, in the course and in the scope of their employment, for example, if they should travel to a different jurisdiction, you as an employer stand to be held vicariously liable if they either cause an accident elsewhere, if they cause someone to suffer damage or loss, or if they may, in certain instances, and I believe that may be the case, if they infect someone in the scope of their employment, if they travel somewhere, or if they attend to a guest or a client, you may be held vicariously liable as far as I'm concerned.
Sure, I want to sit in a padded cell. It's very dangerous living in this world.
Yeah, we're trying to.
Andre, from an insurance perspective, please.
I just wish I had better answers. But unfortunately, I think we all know and that we are in absolutely unprecedented times. So the covers that are typically available in these scenarios would obviously be your employer's liability on the one hand, and an example of another would be directors and officers' liability. Both there to protect the individuals within your business. And you know, right now, if you've got the cover in place and you haven't got an exclusion being driven by insurers, you could arguably have the cover in place. But if you don't have that cover in place, it's highly unlikely that you're going to get it going forward because of the exclusions that insurers have to put in place because of the reinsurance market around the world. So from an insurance perspective, again, I think sadly, the solution doesn't lie there. So when we speak about risk management more broadly, the only advice can really be at this point is, you know, you can mitigate risk in three ways. You can remove it on the one hand, just stop what you're doing, stay in your padded cell, and leave it at that, which none of us are prepared to do because we love the tourism industry. The other is manage it, which is what we're having to do now, is to be as compliant as we can, act as reasonable individuals, go above and beyond to make sure that you're doing and behaving as safely as we possibly can in this current time. And the third traditional way is to transfer that risk into typically insurers, which is the debatable point at this stage. However, in saying that, I think what we are doing at the moment, and maybe there's a question later on, but we're needing to rethink things. We're needing to reimagine how we're going to transfer risk in future. And that's perhaps the positive space that we can be looking at.
Okay, so it's time to reimagineer retroactively. I wish we had seen it coming, but we need to just make sure we prepare for when it happens again, and the transfer of risk will be very different.
Absolutely. Okay. Absolutely. You know, no one saw this coming, Natalia, as you know, not governments, not insurers. We have never faced a lockdown before. So these are absolutely unprecedented times, and we are going to have to reimagineer all sorts of things.
I hate that word, unprecedented. Oh, okay.
No, sorry to say me as well.
I just, before we close off, I want to hand back to Tess just to say a couple of words.
Thank you. Guys, thank you so much. I've been very quiet this session. It was a tough but necessary discussion, and I do hope that we've helped some of you out there who's been listening in and participating, and thank you for attending. Yeah, Stefan, there's a reason. I studied law way back in the 80s. There's a reason why I ran. This is such a quagmire, and it's difficult for people to wade through this. So thank you so much for your time. Very, very valuable time, very valuable responses. And Natalia, thank you again for helping us out with this. Much appreciated. Thank you.
Thank you, Tess. And to Stefan and Andrea for always being so willing to answer my tough questions. I know I sometimes throw them at you and you, but I really appreciate your time, and I really appreciate everybody who was on the call today. We are recording it and we will distribute it. And if you have any other questions, let them come our way. We can only say sorry, we don't know how to answer them, but we want to hear them. So thinking of you guys, stay strong and stay safe. Cheers for now. Bye.
Thank you. Bye-bye.